Hello and welcome to the second part of the fifth lecture. So this is technically lecture 5.2, wherein we're going to be covering a summary of the fundamental rights with a little bit of magnification and of course the doctrine of basic structure and the basics in and around it. Now, before we begin, let's understand this, and I was talking about this in the first lecture also. This is the part which is mostly massively overrated, especially in the UPSC fraternity, because this is where people can flaunt their understandings of the law and unfortunately is not particularly useful as far as the UPSC is concerned. But we'll look at the fundamental rights with the right amount of detail. Right now, largely you've got 6 different classes of rights, so to speak. You've got the right to equality under 14 to 18, freedom under 19 to 22, exploitation in 23 and 24, religion related rights between 25 to 28, cultural and educational rights in 29 to 30, and of course the right to constitutional remedies. Now, before we begin with this lecture, I would highly recommend that you keep the text of these rights available with you. You can download it from the Constitution of India, which you will find as a downloadable link in the description to the video. And the link that I've given you is the link to the latest official text released by the very government of India, the Legislative Department of the Law Ministry. That is the most authentic source of going about it. So a general sense of understanding as to how rights are arranged is, you will see as a whole, they start from very basic umbrella rights such as equality, then they move to something very specific such as cultural and educational. And even within these classes of rights, for example, when you see 14 to 18, you'll start again from a wide to a narrow concept, wherein 14 will talk about general principles of equality, 15 will talk about public space non-discrimination and education reservation, 16 will talk about employment reservation, 17 will talk about untouchability, and 18 will talk about titles. So even within the classes of fundamental rights, so to speak, you will see a funnel approach where you look at a broad right which then moves down to very specifics. And as far as the prelims exam is concerned, at the most you would have seen questions on Article 14, Article 19, you will see a question or two here on Article 21, sometimes just out of the blue on 22. You will at the most see a drop of a question here or there, or 23. You will almost next to impossible see questions pertaining to religion and cultural and educational rights, and this also has to be done in a very basic manner. So while we study this, I'd expect you to, again, I'm repeating this, keep the text of the rights with you. As long as you're just doing exactly what we're discussing, you don't have to really do anything else as far as the prelims is concerned. I'll get my text of the rights also with me so that we can do it together, and it's going to be relatively easy. Okay, so let's begin and let's start with Articles 14. Right, so how we're going to go about this is, we'll look at the right, we'll understand the core concept related to the right, we'll see if there are any applications, exemptions or restrictions originating from the right that are relevant to the exam. We'll understand what the right is available for, who is the right available against, how does the right get implemented, and what kind of an obligation does the right create on the state. So Article 14 is the simplest right and also one of the most powerful rights in Part 3. Very simply, it says, the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. Now, territory of course means the domestic physical territory. There are two concepts that originate from Article 14. The first is something called equality before law, and the second is equal protection of law. Now, both of this become two extremely important principles of Article 14, and we're going to come to that. But I'd also like to remind you of something that we've already discussed in our first lecture, which has a correlation to Article 14, is if we are saying, for example, equality before law, which means all of us are equal before the law, that technically means the law is superior to all of us. And if the law is superior to all of us, what we are referring to is rule of law. And if the law is superior to all of us, then does the law deserve to be superior? Does the law deserve to be something that is above the people who make the law, is above the people that the law seeks to regulate? And for that, the law must undergo two very simple tests for the law to be worthy, for us to be equal before it. The two tests we've discussed in the first lecture itself under the section on rule of law. The basic rudimentary test is procedure established by law. This is explicitly and categorically mentioned in Article 21 and also has a conceptual correlation with Article 14 as well. This basically means that the law has been passed in the right manner, is implemented in the right manner. All the procedures associated with it, or the formalities associated with the passage and the implementation of the law are being followed. That's procedure established by law, originating largely from the Japanese constitution as well as the UK constitution. History is sort of blurred on that front, and an advanced understanding of how the law is worthy to be supreme is of course due process of law, which again originates from the US, wherein we look at the intent of the law, we look at the purpose of the law, we understand whether the law is being used for the same intention as it was passed, whether the law is justifying or is achieving the purpose with which it was originally passed. Like for example, one of the most popular case studies onto this is, let us say, the Supreme Court striking down Section 66A of the Information Technology Act in the Shreya single case. The larger argument was that Section 66A of the IT Act was originally instated in the IT Act so that the government had the powers to shut down the spread of hatred online. But over the course of time, it so happened that Section 66A was being used by the government to allegedly suppress any form of dissent against the government in the online medium, thereby violating Article 19, which gave people the freedom of speech and expression. So the intent of Section 66A was being violated in terms of its execution. Another recent example, especially this year itself, was when a petition was filed in the Supreme Court asking to decriminalize sedition, that the reason sedition as a crime existed in the Indian Penal Code versus the way sedition-centric laws are being used and implemented in the country, maybe there is a slip between the cup and the lip, and there is a need to re-examine the decriminalization of sedition and so on and so forth. So there are several ways in which a due process of law has been used extensively. It is not explicitly mentioned in the Constitution and is a principle which has been integrated into our system by the wisdom of the Supreme Court in the Menka Gandhi case, which also applied a due process of law and procedure established by law. Similarly, for example, there is a provision in our Corruption Act which says that you may require prior sanction from a senior officer before you prosecute a junior officer. The original intention behind something like this was to ensure that that the junior officer wasn't charged with frivolous complaints, thereby preventing him or her to do their job properly. But how it has been used over a period of time is that the junior officer and the senior officer are in collusion and are protecting each other under the larger ambit of the senior officer not providing the prior sanction for agencies to undertake prosecution services. So of course there are several applications with respect to due process of law, with respect to procedure established by law, right? But when we talk about Article 14, and we understand that this is not mentioned in the Constitution but derived judicially, but this is categorically and specifically mentioned in the Constitution under Article 21. The text of Article 14 primarily does talk about equality before law and equal protection of law. It is equality before law which has a very interesting understanding. It simply means that before a law, before a court of law, before the application of the law, people must be treated similarly. The fundamental difference between equality before law and equal protection of law is the way this has to be interpreted, where equality before law says that you will not discriminate against anybody, you will not treat anybody specially, or you will not mistreat anybody on any ground before the law, whereas equal protection of the law is to treat people specially because of the circumstances. So what is common to equality before law and equal protection of law, in fact, are the circumstances, the situations in which they have to be implemented. In equality before law, we are saying that the situations should not play a compelling role, and sometimes the situations can lead to certain specialized exemptions, whereas in equal protection of law, what we're trying to say is that circumstances can be a hindrance in the larger picture of achieving social equality. Now let's focus on equality before law. What we're basically saying is everybody is equal before a court of law or the application of the law. But sometimes the law compels you to take, sometimes the nature of your job, sometimes what you do compels you to take certain tough decisions. For example, if a member of the armed forces in the course of their employment, in the course of their duty, in the course of their service, is killing somebody under reasonable circumstances, that person should not be charged with murder like anybody else who, say, for example, runs somebody over while drinking on a highway. So here the circumstances are playing a negative role. So here equality before law means that there is a negative context to this, that you will be treated equally before the law, and the state will not discriminate against you unless, of course, the nature of your job compels you to take tougher decisions. On the other hand, equal protection of the law says who you are and where you come from puts you at an inherent disadvantage, and the government has to do something to try and put everybody on the same plateau. So we'll come to that later. So the nature of the job, the nature of what you do, sometimes compels you to take tougher decisions, which may be questionable under law, for that matter. And therefore, this gives birth to the idea of immunities, right? This gives birth to the idea of why you need to immune or protect some people from the application of law as it would have to everybody else. For example, the president and the governor have the exact same immunities, right? The exact same set of immunities are guaranteed constitutionally to the president and the governor. And as we were saying, we all lead two lives. For example, who we are at work and who we are at an individual level. So the question is, does the president and the governor enjoy the same immunity for things done in their professional capacity or for things done in their personal capacity? As far as professional capacities are concerned, in the course of them discharging their duties, they have absolute civil and criminal immunity, which means a suit cannot be instituted against them, and a criminal action cannot be undertaken against them for anything that they've done in the capacity of being the President of India or the governor or the lieutenant governor of a state or a union territory. Whereas in a personal capacity, in an individual, personal, private role, that's not the case. But still, you have to protect them so that they are not frivolously charged with things that can hinder them to do their professional work properly. So, for example, let us say the president forgets to pay his or her credit card bills. Then you would have to undertake a recovery from them. In that case, you would have to give them 2 months notice before initiating recovery proceedings. Similarly, if the president runs over somebody while driving a car, a case of let's say driving by negligence and causing death by negligence, till the time you are the president, criminal action can't be taken against you. The second your tenure as the president ends, then immediately criminal action will be undertaken against you, and there will be a relaxation on the statute of limitations, which basically says that you cannot be there's a time bar on the reporting of certain number of crimes, but that limitations is usually relaxed as it is read collectively with immunities. So as far as president and governor is concerned, these are the basic kind of immunities that you have. This is now your follow-up question would ideally be, so in that case, if the president commits murder, as long as he or she is the president, a murderer can be the president of India. Which is why, if it is so severe and if the crime is so serious, then the parliament has the powers to remove the president under special majority 4, and then criminal proceedings can be undertaken. And as far as the governor is concerned, all you need is an order from the president on the advice of the Council of Ministers. Similarly, you have immunities which have been extended to parliamentarians in the country, both central and state legislators, whether it's our MPs or our MLAs. They're also enshrined in the Constitution 105, etc., so on and so forth. But why do you need them? What is the kind of immunity that you want to give the parliamentarians of our country? Think about it in terms of what they do. Parliamentarians have an exceedingly tough job to speak the truth on the floor of the House. Now, I understand that reality might be slightly distorting on that front, but from an idealistic perspective, the job of the parliamentarians is to speak the truth without fear on the floor of the House and bring attention to the issues that need to be paid attention to. And therefore, they should have the freedom to speak what they have to say what they have to, and also they should have the freedom to vote the way they want to, right? Now, this is important. Why is this important? Because ordinarily, if you were standing in a garden talking to a bunch of people and you said something which was defamatory in nature, defamation is something which is a crime, and you may also be liable to pay compensation. But anything said on the floor of the House, you have immunity for it. So no matter how savage the parliamentarian speech might be, it will still be immune from proceedings around defamation because you have a parliamentary immunity for it. Now, similarly, when we say that you have certain privileges to vote the way you have to, and if you are voting, say, on the floor of the House, you cannot be sent to jail for it. You can't be made to pay a compensation for it. Don't confuse this with anti-defection law. Anti-defection law is to disqualify a parliamentarian if they violate certain principles. But even if somebody is removed under anti-defection law, they're not sent to jail. They're not supposed to pay any compensation. They're still protected the way they have to be protected, because one of the principles of anti-defection law is you can't vote against the direction of the party that you're an MP of, right? And that means if you do, then the presiding officer of the House has the powers to disqualify you from the House. That still doesn't send you to jail. That still doesn't impose any liability on you to pay any compensation. Right? You still have the freedom to vote the way you have to. Here also, you can't be sent to jail. In fact, there is a case which is pending in the Supreme Court as we speak, and I will not take the names because of it being politically sensitive, but a member of the Jharkhand Legislative Assembly, who is a relative of a very well-known political figure in the country, was charged with corruption. And the CBI was investigating the matter because the MLA had allegedly taken a bribe to vote in favor of somebody who had to be elected from the Jharkhand Legislative Assembly to the Rajya Sabha seat from Jharkhand. So as we know, elected MLAs elect Rajya Sabha MPs. Right now, the contention that the MLA has taken up in the Supreme Court is that even if I've taken a bribe, I'm immune. So even if ordinarily I would have to go to jail if I'm corrupt, if I've taken a bribe, here I have taken a bribe to vote. And even if that is true, I'm immune because I can vote the way I want to. So it has now created a little bit of a grey area, and the courts of the country are in a flux. But it's a very interesting loophole. I'd actually made a video about this also called the immunity loophole. I'll link it in the description box below if you want more details around it. Similarly, all of you who are preparing for the civil services would also be guaranteed certain immunities under the constitution for civil servants. This is not important for your exam, so don't worry about it. Similarly, you have military immunities for people who are serving in an armed capacity. You have diplomatic immunities for foreign services officers also. India has ratified a UN Convention on Diplomatic Immunities where you have certain protections, you have certain privileges that are accorded to you, and therefore you are technically not being treated the same way as anybody else. Right. So, for example, if anybody else committed a crime, there would be immediate criminal action. Not if you're the president or the governor, because then your profession will stop criminal action to be taken against you. Right. If anybody else spoke in an inflammatory manner, trying to incite some form of hatred or to say something which is fundamentally untrue, or try to tarnish the reputation or the dignity of another individual or an organization, ordinarily you would be charged with defamation, or a civil suit of defamation, or both could be instituted against you. Not if you're an MP or an MLA and you've given that speech on the floor of the parliament, which is why you will notice most of these fiery speeches are often given on the floor of the parliament, because you have the immunity of speech and vote on the floor of the parliament, right? So the work that you do is providing a barrier for you to be treated the same way as everybody else. This actually is a wonderful example that you could use in ethics on the relationship between means versus ends. Now, the title of the article is fairly clear. The article, as I said, the Article 14 in its very first line very clearly says and mentions that the state shall not deny. So the state, it's available only against the state, shall not deny to any person, which means foreigners and citizens as well, the equality before law and equal protection of law. And of course, this is more than enough. If there is an existing law which is treating people unequally, then that law automatically would be violating Article 14, and the courts will look into it. So if it is self-executory, and the state is compelled to maintain equality amongst the laws that it passes or it implements, right? And as far as equal protection of law is concerned, this is a very simple understanding, and we could do this as a simple example, is that everybody is not born equally. Everybody is not born in the same social circumstances, and India unfortunately has been infested with our own created norms of casteism, which are often understood to be endemic to a specific religion. And we've seen centuries and centuries of caste-based violence, and of course there are occupational difficulties, economic disadvantages, social disadvantages, and so on and so forth. So when everybody is not equal in terms of who they are, it is unfair for all of them to compete equally, which is why you'll have to do something. Some relaxations have to be given so that everybody is able to compete together, right? And a simple way to understand this is, if this is a race and if everybody has to have the same starting point, then everybody should have had the same training, the same equipment. But everybody doesn't get the same training, everybody doesn't get to afford the same equipment, which is why, while somebody can start from the starting line here, somebody might have to start from here. And this is the gap that has to be equalized. And that's exactly what equal protection of law is. And this, in of course, jurisprudence, is also the birthplace of affirmative action, which is also a principle of equality, a principle of justice as well. And in fact, reservation policies may be described in 15 and 16, but they owe their origin to Article 14. Article 14 allows the state to have any form of affirmative action. Reservation is one of the forms of affirmative action. 15 and 16 tell you how to, but 14 allows you to have it in the first place, and that is why it's called the origin of affirmative action. So equal protection of law is treat like people like, treat people with similar circumstances similarly, and therefore this is the birthplace of affirmative action as far as the Constitution is concerned. Right now, this is enough. You really don't need anything else as far as Article 14 and the prelims is concerned. We now move to Article 15. Now, Article 15, as we understand, have 6 clauses, and they're fairly complex clauses, and there is a lot of Supreme Court intervention. In fact, if you look at Article 15 and 16, the highest number of judgments and constitutional amendments have happened collectively in 15 and 16. 21 may have the highest number of derivations, but judgments and constitutional amendments, and more specifically, the highest amount of constitutional amendments in fundamental rights have actually happened to Articles 15 and 16 together. Right now, Article 15 largely does talk about non-discrimination, and of course, it talks about education-based reservation. And as a whole, it is available for citizens only, because you're trying to do something special. You're trying to give a platform for people, so therefore you would want to keep it only for citizens. However, some provisions are actually available for foreigners also, which is where our textbooks often get things slightly wrong. And of course, they're available only and only against the state, because you're trying to prevent. But however, there are certain provisions of Article 15 which are also available against private as well, and I'll come to them as and when we come to them, which is why the prelims will not really ask you these technically complicated questions. Now, as far as our reservation policy is concerned, we'll come to the 2 dimensions, we'll come to horizontal and vertical, we'll come to the principles in just a bit, and I'll give you a basic idea out of this, and beyond this is not particularly relevant. Okay, so now we'll look at 15, 1, 2, 3, 4, 5, 6 together, and then we'll move on. All right. Okay. Article 15, Clause 1. Now, Article 15, Clause 1 begins by saying the state shall not discriminate, which means specifically Article 15, Clause 1 is available specifically only and only against the state, right? And it is, since it is available only and only against the state, and it just says that the state cannot discriminate against people on a certain number of grounds, which means this is self-sufficient. You do not need any other law than 15.1, which already lays down the criteria on which you can't discriminate people, and it is of course compelling, and the government and the state is bound by this in the sense that they have to make sure they uphold 15 Clause 1 under all circumstances. Right, and of course it is only and only available for the citizens. Now let's look at 15 Clause 1. 15 Clause 1 basically says you can't discriminate against people on the basis of. Now I have rearranged the words because it's easier to remember like this: CRRSP, which is caste, race, religion, sex and place of birth. It's similar to the word crisp. So caste, race, religion, sex and place of birth. And it mentions 2 very important words, which is only on caste, race, religion, sex or place of birth, or on collectively all of them. So what is not allowed? You can't discriminate only on the basis of caste, race, religion, sex or place of birth, and you cannot discriminate on the combination of this. So any combination of C plus R plus R plus S plus P. So caste and race, all of them combined, sex and place of birth, you cannot discriminate against people on the basis of this. But what if there is another criteria? Anything else which is not mentioned here, that is perfectly okay. And the Supreme Court through judgments have said this is all right. If you want to discriminate on anything apart from this, as long as it is reasonable, as long as your reasons of adding something like this is justified, it is helping the cause that you're trying to achieve. The legal terminology for this is intelligible differentia. If all of that is in place, then you've got nothing to worry about. That is something you can do. But only and any of them means this. Simple. Nothing more than this. is relevant as far as the prelims is concerned. I can get on to a romantic association and discuss, my love for discussing the derivations of CRRSP, but that's going to be wasting your time on my accord, and I can't live with that. So that is that, right? Now, here's where things get interesting. Article 15 clause 2 refers to non-discrimination in public spaces, right? Again, on the same criteria. But very interesting, these public places can be owned by the government and can also be owned privately, because it mentions restaurants, it mentions a lot of other places as well. Now, it doesn't mean government-owned restaurants, does it? So it could mean public restaurants, it could mean shops, it could mean hotels. So any of this CRRSP only, or any of them, that in fact is not allowed. Plus X is okay. So if there is a restaurant which has a dress code and that dress code is considered to be reasonable, that still could be understood by the court, and that could be allowed. But interestingly, because this restaurant or a hotel or a shop could be privately owned, technically by jurisprudence, this right could actually be available against the state as well as a private as well. Otherwise available for citizens. This is self-sufficient in its own way. You don't need supporting law for this, and the government has to maintain minimum standards to do this, right? Now is where you get opportunities, okay? Now we move to Article 15 clause 3. Article 15 clause 3 has been in the Constitution ever since the birth of the Constitution. It says that the state can make special provisions for women and children, of course identifying them as vulnerable sections. Now carefully, Article 15 clause 3 nowhere mentions citizens who are women and children. So there is a case to be made that this provision could actually be available for citizens and foreigners both. And if you think carefully, this paves the way, or this sort of creates a way for creating special provisions for children, that you could have Article 21A, which is right to education, which is also available for all children, whether they're foreigners or not. So this is also reaffirming that you can have fundamental rights for special provisions for all children, whether they're Indian children or foreigner children, right? Of course, is available only by the state. And because the article in itself says that the state can create special provisions, these special provisions could be another amendment to the Constitution, could be any other law, could be any other scheme, order, anything. So obviously it is not self-executory, and it does not give you any timeline that the state has to necessarily do it by now, or the state must necessarily should have completed it in that specific time, which is why it is actually enabling in nature and not compelling in nature. Now you'll be able to understand the difference between a compelling fundamental right and a non-compelling fundamental right, right? Or an enabling fundamental right. Now, Articles 15.4, 15.5 and 15.6 are the ones which primarily deal with education-based reservation. Now, first things first, through Supreme Court judgments, we've also understood that reservation policy in India is two-dimensional, which means, very simply, for example, it is SC, ST, other backward classes, and EWS, right? What you could do is, this is dimension 1, or this is layer 1. You can integrate layer 2 within these parameters. So let us say persons with disability. So it becomes SC, persons with disability, SC, persons without disability. Similarly, ST PWD, ST non-PWD, OBC PWD, OBC non-PWD, EWS PWD, EWS non-PWD. Similarly, general non-PWD and general PWD. So this is basically what is meant by a two-dimensional policy and nothing else. Okay. Now, Article 15 clause 4 very clearly says you should have social and educational you should have reservation, or you should have special provisions for the advancement of social and educationally backward classes and SCs and STs. And think of this carefully. This was added in the first amendment to the Constitution itself. This means technically this amendment was inserted by the Constituent Assembly, which was functioning as an interim parliament at that time. Right? So the very first amendment actually added a general provision which said that you should try as much as possible to advance socially and educationally backward classes and SCs and STs. So obviously this will only be available against the citizens and is available against the state, and it does not mention the kind of provisions, which means that you will have to create additional provisions, thereby making it non-self-executory, and it allows the state to create further laws and actions. Now, interestingly, this 15.4 says you should do something to advance these classes. 15.5 and 15.6 tell you what that something is. And what that something is education-based reservation for both government and private. The text of the article very clearly mentions government and private. Okay, very clearly mentions government and private, and of course it excludes minority institutions under Article 29. Of course, because minority institutions are for a minority already, and they are already catering to a very specific subset of people. Right? So this was inserted through the 93rd Amendment 2005. 15.6 was inserted through the 103rd Amendment 2019. Both of them available for citizens, available against the state. On the basis of this, you can now create additional information or additional laws, because what does the text say? Nothing shall prevent the state from creating special provisions that provide for education-based reservations. So on the basis of this, you could have your universities, or you could have your schools, or you could have your CBSE, you could have your IIT councils release orders. You can make changes to the IIT Act, you could make changes to the UGC Act, saying that our admissions will always comply with a certain amount of criteria, right? And of course, this EWS is the percentage is mentioned here, and it has to be taken as 10% out of the general category, and it also says that the total should not cross 50%. Very interestingly, the SC, ST, OBC reservation should not cross 50%. This will be 10% for EWS, and general will be 40%. This was laid down in the Indira Sawhney judgment. The Constitution has taken Indira Sawhney judgment's order, and on the basis of this order, because this judgment came before 2019, and therefore in 15 clause 6 they've mentioned that this 10% will not violate the 50% limit on SC, ST, OBC. A beautiful way where Supreme Court judgments lead a guiding light towards prospective constitutional amendments respecting Supreme Court judgments. All right. So this is the entire ecosystem, with folded hands and a lot of hope. I hope that you don't do anything more than this as far as Article 15 is concerned. It is not needed, and it is going to be a waste of your time. This is more than enough. This is it. You don't need to know the technical specifications beyond this. If this was a mains class, we could have spoken about Indira Sawhney and Lakshmi Narayan and Jarnail Singh and the recent amendments to EWS, its implications on center state. We would have spoken about Mandal Commission. We would have spoken about a whole bunch and a range of things. But for prelims, this is anyways forbidden territory. So don't waste your time any more than what I've discussed here already with you. Okay. Now we move to Article 16. Right. Now, when we discuss Article 16, we understand that on the whole, Article 16 will also have 6 clauses. It largely deals with public employment and also deals with reservation and promotion with respect to public employment. Now, on the whole, on law of averages, it's of course available only for citizens, and it is available against the state. Now, this is public employment, so everything mostly will be available against the state only. Now, Article 16 Clause 1 is your general article, is your foundational article, which says that we have to endeavor and the state, and there shall be equal opportunity for all citizens in matter of employment as far as the employment is under the state. So very clearly it tells you that it is against this, it is against the state, and it is only and only for the citizens, right? Now comes the details of it. Article 16 Clause 2. When we are saying that everybody has to be treated equally, which means there cannot be any discrimination. Understood? If there cannot be any discrimination, then what are the grounds on which there cannot be any discrimination? We've got CRR-SP already from Article 15. We've got doctor here also. Okay, we've got doctor here also. So CRR would mean caste, race, religion, sex and place of birth, and here D and R would mean D for descent, and R would of course mean residence, right? So we've got Dr. Crisp, right? So descent, residence, caste, religion, race, sex or place of birth. So this is residence here and this is descent. So these are the two additional discrimination grounds that have been added, and the principles remain the same. You can't discriminate on any of them or a combination of any of them, but if you need to do something else, then it is all right. If there is another discrimination criteria that you're adding and it seems to be reasonable, it is okay. For example, descent does not mean the same thing as domicile, right? Or residence does not mean the same thing as domicile, right? So these are things that we have to understand. These are things that we have to be particularly careful about, right? So again, in fact, this idea of having a domicile criteria is implicitly mentioned in the forthcoming articles as well. Now, of course, this is again the same thing. It's a full-fledged article, 16 Clause 1, available against the citizens, for the citizens, against the state. This is again a comprehensive, self-sufficient article within itself, so it is self-explanatory, and the government has to ensure that there are no laws or no institutional mechanisms which are violating these provisions of 16 Clause 1 and 16 Clause 2. They are self-executory and they're also compelling. So both of them have the exact same characteristic phenomena, right? Now comes Article 16 Clause 3, which is very interesting. Article 16 Clause 3 says, it is the Parliament, not the state legislatures, who have the powers to make a law on a policy with regards to class or classes of employment. And it is only the Parliament which can do this, right? So for example, for a long time we've had restrictions on women in combatant roles, or we've had some restrictions on domicile based on state employment. For all of that, it is the Parliament that gets the capacity to make laws, and that those classes have to be reasonable. Now, very interesting. Nowhere does it mention the word citizens under Article 16 Clause 3. Why? Because even foreigners can also work under the government, and the Parliament can create a law in and around recruiting foreigners living in India and working for the country, right? Or living in a specific territory, residing in a specific territory. That is fairly possible, which means theoretically it is possible for 16 Clause 3 to be applicable to citizens and foreigners as well. Again, this is advanced law, which is why I don't ever think this is going to be asked in your exam. But anyways, available against the state, it is non-self-executory and it is enabling in nature, because all that Article 16 Clause 3 says, it's written in a slightly complicated manner, but all that it says is, nothing in this article shall prevent the Parliament from making any law in regard to class or classes of appointment under the government or any union or any office under the state any requirement within the residence of that state or union territory, or for that matter the country as a whole. Which means you can create a law wherein you can regulate on residence, and the only person who can do that is the parliament, and therefore Article 16 clause 3 is sort of an exception to Article 16 clause 2. Is it relevant for the exam? Absolutely not. Now comes Article 16 clause 4, which says that the state should provide for provisions, or should provide for measures in which there can be advancement of backward classes. And because OBCs are not mentioned anywhere else, we take the origin of OBC employment reservation to Article 16 clause 4 itself, right? Again, available only for citizens, available against the state. This is non-self-executory because you would require the state to make additional provisions, and therefore you are supposed to take certain affirmative actions. Now the plethora of amendments begin. Article 16 clause 4a, right? Article 16 4a. Now, the article as a whole was added via the 77th Constitutional Amendment of 1995, which again basically provides for reservation to SC and ST communities, and reservation originally only in the recruitment. But through the 85th Constitutional Amendment of 2001, it provides for reservation in promotion as well, and it also refers to something called consequential seniority, which basically means that if a person has been promoted, even if it is because of reservation and therefore is now senior, that person will continue to command that seniority for the rest of the career. It's basically that. Will the prelims ever ask you the meaning of this? Absolutely not. Now, this is again done as a response to several Supreme Court judgments and so on and so forth. But again, don't worry too much about it. Right? Now, available only against the citizens because this is proper employment reservation. Why would you give it to foreigners? Available only against offices of the state. It is non-self-executory, which means you will use Article 16(4)(a), and on the basis of this, several recruitments that happen across the country will therefore have employment rules, employment orders, employment notifications on the basis of reservation, which is provided under Article 16 clause 4, and therefore it is also enabling in nature, right? This is more than enough. Now we look at 16(4)(b). Very quickly, it talks about two principles of reservation policy. This was added via the 81st Amendment 2000. Don't need to remember the amendment also. I'll tell you which ones are to be remembered. It basically talks about two things. First, it talks about carry forwarding, which means if there are unfilled reserved seats from the last year, they will be carried forward to the reserved category next year. And even if by carrying it forward, even if it is violating the 50% margin, that's all right. So for example, let us say there are 100 seats, out of which there were 50 seats which were, for example, reserved for, let's say, the SC community, right? The number is obviously going to be lower because collectively it can't be more than 50. Let us say only 40 seats got filled. This is in 2022. Now in 2023, you will have a total of 110 seats where these 10 seats have been carried forward and the total SC seats will be 60. And even if there is, if there are 60 seats out of 110 which seem to be reserved, or 60 out of the original 100, that's all right because you're carry forwarding unfilled seats or leftover seats from last year. So that's that. Again, available for citizens, available against the state. On the basis of this, will you have your employment laws and regulations in place, and therefore it is non-self-executory, and it enables the government to have further guidelines. All right, and then you have Article 16 clause 5. It basically says this reservation policy is not applicable to religious institutions and the employment structure or the occupational structure of any religious institution whatsoever. Now again, now the interesting part is here it does not mention citizens, because technically you can have foreigners occupying leadership positions in religious congregation organizations. So technically this right by jurisprudence can be available to citizens as well as foreigners, but only available against the state. It is non-self-executory and enabling in nature, and therefore there cannot be any law which provides for reservation to a religious institution, right? Then you have Article 16 Clause 6, which is basically the EWS addition done by the 103rd Amendment, that 10% from the general category, and it will not affect the 50% SC, ST, OBC, because that is done on social and educational backwardness as mentioned in the earlier articles. This is done on an economic criteria as well, and of course this would be on in state employment. Simple enough, available for citizens only against the state, and on the basis of this the government can make laws, and it is therefore enabling in nature. And this is it as far as Article 16 is concerned. Now comes Article 17. Article 17, very interestingly, talks to you about two things. First, it declares that that untouchability is prohibited. But the Constitution declaring untouchability to be prohibited will really not make a lot of difference unless you also add a lot of deterrence value to this. And the only way you're going to add deterrence value to untouchability is by making sure that it is a crime, right? Now, the text of Article 17 is very clear. It mentions person, it does not mention citizens only, and therefore Article 17 clearly says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability shall be arising out of untouchability shall be an offence punishable under law, which means not only is untouchability criminal, but if there is any disadvantage given to a person because of the practice of untouchability, that will also be criminal. So this is of course available against citizens and foreigners both, because the article does not mention citizens. If it does not mention citizens, you will assume it is available for everyone unless you have compelling reasons for it, and nobody can practice untouchability. So it's one of those rare rights which are available not only against the state but also against the private entity as well. So can you file a writ petition in the Supreme Court against an individual, a private individual practicing untouchability? Well, technically yes, but the writ petition is not really going to make a difference, because except for habeas corpus, all other writs are only available to the state. So what you could possibly do is, in that case, file a writ of mandamus asking the court to direct the nearest police station to take appropriate action against the instance of untouchability that you are trying to report to the court, right? And of course this would be non-self-executory in nature and is of course enabling in nature. On the basis of this you are able to create prevention of atrocities against SC/ST Act, or abolition of atrocities against SC/ST Act, and so on and so forth. This itself is not enough because the Constitution is not a criminal law. Right now, Article 18 had a little bit of an excitement or surprise last year in the UPSC, or I think last year, where there was a question on titles. So Article 18 broadly looks at titles, and certain provisions are for citizens, certain provisions are foreigners, and certain provisions are for both. Right now, Article 18 very interestingly contains the only fundamental right which is available only against a foreigner, only for a foreigner. We'll look at it very interestingly. So Article 18 Clause 1 basically says military and academic titles are allowed, and apart from that the state cannot give any title, and the interpretation is titles and awards don't mean the same thing. So Bharat Ratna is an award, okay, it's not a title, right? So military and academic titles are allowed, Field Marshal is allowed, that is perfectly okay, it's a military title. Now this is a right which is available against for both citizens and foreigners, and because it is the state who's giving you these titles, so it is against the state. This is self-executory in nature. As long as the government is not giving you anything apart from a military or an academic title, that's okay. Everything else is going to be a problem, and therefore it is of course compelling in nature, and you have to conform to these principles under any and all circumstances. Right now, apart from this, You've got a few more provisions for Article 18, which is 18.2, which says citizens can't accept title from a foreign state. So obviously this is only and only for citizens. It's against the state, and it is self-executory, and it is compelling in nature, which basically means that this is enough, this is self-sufficient, you do not need any additional law. Now, very interestingly, though this is the right, so what if a citizen A accepts a title from a foreign country, right? A foreign country is not justiciable in India. So what you do is you file an objection with the state that the state did not take any action preventing the citizen from accepting that title, which is why you need prior permission, right? Now 18 clause 3 is the only fundamental right in the constitution which only talks about foreigners, which basically says foreigners working for India cannot accept title from a foreign state. So therefore it's only available for foreigners, and if you're working for India, which means you're working for the Indian government. Now Indian government could mean central government and state government also. Nowadays you also have a lot of consultants who are hired by central and state governments to advise them with certain expertise when it comes to public policy matters, in lateral entry and so on and so forth. So of course it is available only against the state. It is self-executory, you don't need a law to further implement it, and this is as it is good enough, you don't need anything to support it per se. Then you have Article 18 clause 4. No one working for India can accept a gift or anything or a present or an emolument from a foreign state. Working for India means working for either the central or the state government, and no one means it is available for citizens and foreigners both, and it is available against the state, again through the same mechanism as I mentioned for 18 clause 2. It is self-executory and therefore it is compelling in nature. So Article 18, though extremely unlikely to be asked because it was asked very recently, but a basic understanding is more than enough. Now we come to the hotly debated fundamental rights of Article 19. For mains, Article 19 is extremely important. For the prelims, because of the nature of controversy around Article 19, it has to be done with an extremely refined degree of caution, right? So Article 19, interestingly, is one of those rare fundamental rights where you have substantive rights and reasonable restrictions written separately, and that's what comprises most of Article 19. So on the whole of it, Article 19 is available against citizens, but there could be certain ramifications of it. So how it works is, the freedom is under Article 19(1)(a), and the reasonable restriction is under Article 19 clause 2. And the highest amount of reasonable restrictions are in the first freedom itself, which is the freedom of speech and expression, which of course translates to anything verbal, anything written, creative, the right to remain silent also, the right to sing, right to dance, right to paint. This also has modern day ramifications on regulation of OTT platforms, on censorship. It also has ramifications on how much of defamation is okay, how much of it is not. It also has implications on surveillance, because that also indirectly affects, you know, the rights of journalists to report freely, and therefore also have an issue with information. What is interesting is the Supreme Court very clearly says that your right to information is an implied fundamental right, which means it is derived from Article 19 clause 1 clause A. Basically meaning, if you have the right to say something or to express yourself, which could be in an oral or a written format, for you to express your opinion, you should have the information on the basis of which you can express your opinion. And if you want to express your opinion on matters of the state, then the state must empower you with the right information for you to have an accurate opinion on the same. And that is why right to information becomes an implied fundamental right under Article 19 clause 1 clause A. Very, very important, very, very interesting, and very, very crucial, right? So that is something that we must understand, right? So of course, Article 19 clause 1 clause A will be available only for the citizens against the state. It is self-executory in nature, and the government or the state does not have to make any other law guaranteeing people the right to freedom of speech and expression, and therefore it is compelling in nature. But as far as restrictions are concerned, the state will have to make laws if they need to, if they want to implement these reasonable restrictions as well, right? So your reasonable restrictions are territory, sovereignty of the country, relations with neighbors, public order, decency, defamation, contempt, and offense. So contempt, of course, is something we'll study in judiciary also. This is contempt of court. There is civil contempt and criminal contempt. Civil contempt is when you don't follow a court order. Criminal contempt is when you tarnish the reputation of the court or the judge specifically. Criminal contempt can lead to imprisonment. Civil contempt can lead to fine. Criminal contempt can also lead to fine and imprisonment, and this is regulated through the Contempt of Court Act. Similarly, defamation is under the Indian Penal Code, so you can have supporting laws for this. And because the text is nothing shall stop the state from making provisions on these grounds to restrict Article 19 clause 1 clause A. So it's available against citizens, available only for citizens, against the state. It is non-self-executory, and it is therefore it is enabling in nature. That is why you will hear of Contempt of Court Act, which is why you will often hear of something called provisions with respect to sedition. You will often hear of amendments which are made to, let us say, the National Investigation Agency Act. You will hear of something called Unlawful Activities Prevention Act. So these are all legislations that have been made on the basis of reasonable restrictions that essentially are important in the overall well-being. And this is also a fantastic way to sort of link it to ethics in terms of utilitarianism. When I'll do your ethics course for you on YouTube in a few days from now, we'll start recording on that front. I'll keep linking it to that arena as well. So that's Article 19 clause 2. Now we move to Article 19(1)(b), and the restrictions are in again Article 19 clause 3. This is peaceful assembly without arms, so you can gather around, and this has largely been in the news because of the farm law protests, the citizenship amendment protests, and so on and so forth. Extremely unlikely to be asked. The provisions and the pattern remains the same. Available against citizens, available for citizens, against the state, self-executory and compelling. However, the restrictions are going to be non-self-executory, and the state can make laws to implement those restrictions, and it has territory, sovereignty, and reasonable restrictions. So, for example, peaceful assembly without arms, your reasonable restrictions could mean permission from the magistrate under CRPC, or the magistrate having the permissions or the powers to cancel a peaceful assembly if there are enough reasons to do so, right? Then you have Article 19 clause 1 clause C, the freedom to form associations, unions. This again was in the news in the context of the farm law protests, and a recent Supreme Court judgment, actually almost 7-8 months ago, a Supreme Court judgment on the composition of multi-state cooperative societies, and where the center only has jurisdiction on multi-state or interstate cooperative societies, while the states can regulate intrastate cooperative societies. This was added by the 97th Amendment of 2001. Again, the freedom will always be self-executory and compelling, whereas the restriction would be non-self-executory and enabling, right? Now, Article 19(1)(d) and 1(e), which is basically the freedom to move freely throughout the territory of India, and the freedom to have basically the freedom to move freely and the freedom to reside in any part of the country. Because they're related to each other, their reasonable restrictions are the same. So Article 19 clause 5 is the common reasonable restriction to 19(1)(d) and 19(1)(e). Again, same principles. You have the right to move freely, but in the interest of general public or interests of scheduled caste or scheduled tribe, they can be restricted, which is why you would have often heard of something called Schedule 5 area, Schedule 6 areas. You would have heard of a visiting permit. You would have heard of disturbed areas. All of those exist. You would have heard of provisions with respect to curfews and lockdowns, because they're essentially restricting your right to move freely. So again, the core, the substantive freedom is self-executory and compelling, but the restriction is non-self-executory and therefore enabling. Right? Then you have 19.1.1G, 19.1E, sorry, which essentially deals with the right to reside or settle anywhere. Same ecosystem, same examples. The reasonable restrictions remain the same as the previous one. Now 19 clause 1 clause F related to property. Property was moved from a fundamental right to a constitutional and a legal right. So 19.1F has been deleted. So you've got 19.1G, and the restrictions to 19.1G are actually very interesting. So you've got the freedom to profession, occupation and trade, again available for citizens, state against the state, self-executory and compelling in nature. But the restrictions to 19 clause 6, which are mentioned in 19 clause 6, the state can mandate qualifications, which means you have to be a registered medical practitioner for you to practice medicine, or you need to be registered with the Bar Council to practice law, or you may need to have a fitness certificate if you want to be a commercial pilot in India. All of those are valid educational or certification restrictions. Not only this, while you have the freedom to work in any profession that you would want, there could be certain sectors, certain professions which could be exclusively reserved for the state. For example, you can't build your own private armed nuclear reactor in India, right? We've not seen those days yet. That's been reserved. For a very long time, you would have noticed that that railways was exclusively a government monopoly. Space was exclusively where the government would work under. So all of that was justified under Article 19 Clause 6. Right? Now, interestingly, here, very important, it does not mention citizens. So it is something which is available for both citizens and foreigners, because you can mandate and you can prevent also certain set of people to work here. Available against the state also, self-executory in nature, and it is enabling in nature, which means this is enough. And on the basis of this, you can also have other laws to make this or call this into effect. So this is Article 19 for you. Simple enough. Now, Article 20, then we'll move to 21. 20 largely deals with offences and the protection when somebody gets charged with offences. This also is the birthplace of something called the Principles of Natural Justice, which basically means that you have the right to a free and a fair trial, and you also have the right to not be forced to be in a biased trial or to forced to be a witness against yourself. So this principle of natural justice was also evolved in the Menka Gandhi case, and there have been several other cases as well. Now, Article 21, 22 and 23 give you three very specific principles. They're exactly the same. They're available they're available for everyone. They're available against the state. They are enough as it is. You don't need any supporting law for it, and therefore they are all enabling in nature. They're all enabling in nature. Sorry, they're all compelling in nature. You don't need any additional law to put all of these into motion, right? So, Article 20, Clause 1. Criminal law can't be retrospective. That's what the basic essence is. It basically means that if, for example, today is the 1st of January 2022, and let us say X has committed a crime, it should be a crime on the 1st of January 2022. What if, let us say, what he has done or what she has done is not a crime? On the 2nd of January 2022, the Parliament can't make a change in the law, make it a crime, and then charge X with it. X will not be charged with it. For you to have committed a crime, it should be a crime on that specific day. The crime, the intensity of the crime, the punishment prescribed by that crime. Which is also why, if you remember, in the Delhi gang rape Nirbhaya case, the juvenile who was arrested as one of the accused in the gang rape, because of provisions that existed on the date of the commission of that gang rape, said that children and adults will not be treated similarly for any crime whatsoever. Later, they made changes to the Juvenile Act and said that for heinous crimes, for serious crimes, children and adults should be treated the same way. But that child who was a part of that heinous activity was still being treated by a lenient juvenile law. So, criminal law can't be retrospective, which also means civil law can be retrospective. So you can have a civil law like a tax law. For example, you would have heard of retrospective taxation. That can be applied on a back date, right? Or for example, a lot of you, once you get into services, will receive a lot of your salaries and pensions in arrear forms also. That is essentially an element of civil law. That is all right. But criminal law can't be retrospective, because if a crime like that did not exist, or the punishment of the same stature did not exist, it would be unfair for the person to be charged with something that did not exist the day the crime allegedly happened, right? Violates principles of natural justice. So, available against citizens and foreigners. The second principle is the principle of double jeopardy, which is illegal. Double jeopardy means you can't be tried for the same crime twice. A simple application of this would be in the case of under trial prisoners. We understand that more than half of the prison population in India are under trials, right? So how does that work? So for example, let us say somebody has committed a crime. The maximum punishment for that crime is 5 years. But the case has been going on for 7 years. The person's bail has been denied and the person has been in jail, has been in custody for 7 years. After 7 years, the court finds this person guilty and says, we are going to sentence you for 5 years of prison. The person is going to shout back at the judge and say, boss, I've already committed 5 years of myself to jail. I've given you 2 extra years as a bonus. I'm going to now walk out of here because I've already served the maximum punishment. Because this person has already served the maximum punishment and you give him another 5 more years, what you're essentially doing is charging the person for the same crime twice. That is the basic principle of double jeopardy, right? And that is of course illegal, can't happen. Third principle is the principle of non-self-incrimination, which means you can't be forced to give any evidence against yourself or testification against yourself, which is why you would notice that even if there's a confession that somebody gives to the police, that confession in open court has to be verified in front of the judge. A confession given to the police is not absolute in terms of substantive evidence before a criminal trial. This also translates into now banned practices such as narco analysis, which was hotly in the news during the Arushi Talwar murder case, where one of the suspects was treated to narco analysis. Narco analysis is injecting a person with a drug that makes the person in a semi-conscious state of mind, with the hope that the person is only going to speak what the real facts are. Okay, so that is also illegal because you are compelling a person to say something against themselves, right? So this is no self-incrimination. Why is this important? Because you are forcing a person to say something which the person doesn't want to, or you might just force the person by brutality of the police to say something that the person may have not even committed to. These three as it is on their own as a whole are enough. You do not require any additional laws. Even if you do have those additional laws, it is fine, but you don't need them per se as far as the provisions are concerned, which is why they're all compelling in nature. They are self-executory. You do not need any additional law, supportive law. They're against the state because we're talking about arrests, and of course are available against everybody, whether you're a citizen or not, right? Now you look at Article 21, the holy favorite of this exam and the world in general, life and liberty. The most, now I don't want you to sit and memorize what all is included under life and liberty, but I'll give you a very simple trick to do this. For example, a few years ago, there was a question in the UPSC which asked you, the right to marry is a fundamental right under what? Life and liberty was one of the options. Expression, freedom of expression was one of the options. Equality was one of the options. And of course, I think this non-discrimination 15 was one of the options. Religion was one of the options. If your option contains Article 21 and there is no direct derivation of any other article, please close your eyes and choose Article 21 as the correct answer. So you have the freedom to marry who you want to under Article 21. Now I remember some students had come to me and argued rather innovatively, sir, marriage is a form of expression, sir. So therefore we are expressing ourselves when we are getting married. All said, but it is also a matter of your choice. It's your life. You have the choice of marrying who you want to. How you get married to somebody or not is of course a different story. You can plug it under Article 19. How you can plug privacy also under Article 19. But the primary article will always be Article 21, right? And the most important derivation for life and liberty is privacy. UPSC has already asked this at least twice before, so don't worry too much about it. This is again available against all, available for all citizens and foreigners, only available against the state. This is self-executory in nature. Very interestingly, it has both components of compelling and enabling in nature, which means Article 21 on its own is enough. But if you see, it says, no person shall be deprived of his life or personal liberty except according to procedure established by law, which is also reaffirming the fact that procedure established by law has been mentioned categorically under Article 21. Right? Now, which means everybody has the right to life and liberty unless the government makes a law which restricts your life and liberty. And that has to be a reasonable law, right? So that is why it has elements of both compelling and enabling in nature. Article 21A, which also has conceptual sort of ties with 15 clause 3, where you can make special provisions for women and children, is essentially the right to education, which is the 86th constitutional amendment, which says it is free and compulsory education for 6 to 14. It is available against the state but available for everyone. And the article itself clearly mentions that it is an enabling right and there will be a law made for it. Article 21A very clearly says the state shall provide for free and compulsory education of all children of the age 6 to 14 in a manner as the state by law determine, which means on the basis of this, you will create an ordinary law called the Right to Education Act, which can also have the right to education rules. You can have an organization called the National Commission to Protect Child Rights. You can have a scheme now called the Samagra Shiksha Abhiyan, which subsumes all of it, but previously the Sarva Shiksha Abhiyan. You can also integrate midday meal into it and you can make an ecosystem out of it. That's all right. But largely this is what Article 21A is about. Very simple. Keep it simple, keep it clear. You'll not go wrong with these kind of questions. There's no need to confuse yourself with unnecessary details. Now comes something that was asked last year also, but the question that was asked on judicial custody and police custody could easily be solved with the application of rule number 3, which is separation of powers, where if it's under judicial custody, then you can't investigate without the judge's permission. If it is under police custody, then of course the police can. You don't need to know criminal procedure code for it. Anyways, so articles 21 clause 1 till about 22 clause 7, 22 clause 1 till 22 clause 7 largely deal with arrest and detention. It also deals with a specific type of detention called preventive detention. So arrest and detention means a crime has happened, something has happened and the police has taken you into custody. Preventive detention is there is a suspicion, there is a reasonable belief that you are going to commit something illegal or you're going to cause some trauma or trouble. So we are going to keep you in custody. That's the only difference. Okay. Now, it is in fact the only fundamental right, parts of which have not been notified for implementation, which means parts of these rights are still not enforceable by nature because they haven't been notified by an order. Those are basically 22.4 and 22.7, the setting up of a board and the timelines and so on and so forth. So Article 22 clause 1 basically says you have the right to be informed and the right to be represented. When you are arrested, you have the right to be told why you are arrested and you have the right to hire the services of a lawyer, somebody from our legal community to help you get out of it. Again, This is arrest, which means it has to be available for everybody. You are not creating an arrest yojana out of it. So you're basically providing it for everybody, right? So it's available for all citizens and foreigners. It's available against the state and private because, very interestingly, although the state can arrest you, but detention can also be done by somebody who's a private agency, and that will still be illegal. And that is how you can move the court for something called habeas corpus. It is self-executory in nature and it is compelling. You don't need any further laws for this. 22 clause 2 says if the police arrests you, then if the police arrests you, then you have to be taken to a nearby magistrate within 24 hours. The travel time and holidays don't count, which is why you will see most high profile arrests happen on a Friday evening so that the police gets 2 full days to do their business. Again, available against everyone, against the state and private, and of course self-executory and compelling in nature, right? Now 22 clause 3 particularly deals with preventive detention. Now preventive detentions are, firstly, the rights that you get under preventive detention is not available against an enemy alien, which means it's available to citizens and foreigners except enemy aliens. All right, this is important. The basic difference is in preventive detention, you have the right to be informed why you have been detained. You also have the right to challenge the detention order, but you do not get the absolute written right of representation by a lawyer. That's the difference between arrest and preventive detention provisions. Available only against the state because only the state can preventively detain you. Self-executory and is compelling in nature. You don't need any additional provisions for this. 22.4 and 22.7 are not notified yet. They basically talk about provisions with respect to authorities which can authorize detention and preventive detentions. Now 22 clause 5 basically talks about the right to inform, and which is basically an extension of 22.3, and 22.6 also says that under reasonable reasons the government can choose to not disclose publicly the reasons as to why somebody was preventively detained, because it can cause frenzy otherwise, right? For example, if a very well-known leader is detained because you think the leader is going to cause communal hatred, and if you arrest the leader or detain the leader, then the people might, cause a communal riot. So sometimes the government may not disclose this publicly as well. Anything more than this, very honestly, is irrelevant. Please don't bother as far as the exam is concerned. Okay, now we move to 23 and 24, which are your exploitation rights. Now 23 talks about human trafficking and 24 specifically talks about child labor. Now 23.1 says human trafficking is of course illegal. And what is human trafficking? Human trafficking is when somebody is made to work without their consent and the work dominantly is illegal, right? It has nothing to do with whether you get paid for that work or not. Begar is when you are made to work but you're not paid for it. Forced labor is when you don't want to work and simply there's an absence of consent. So this becomes like an umbrella of violations against people and the dignity of labor and the work around it. Of course, available against citizens and foreigners, and because private agencies can also do this, it's available against the state and private, and this is not enough. You will require laws to support this, which is why you have the Prevention of Immoral Trafficking Act, which also regulates prostitution and particularly refers to how solicitation of prostitution is illegal, but an individual non-commercial establishment is still legal, right? So non-self-executory, and of course it's both where the state has to prevent human trafficking and can make further laws with respect to this. This is Article 23 Clause 1. Now, having said that, if needed, under Article 23 Clause 2, the state can also provide for compulsory service without any discrimination on these reasons, which is CCRR, which is caste, which is caste, religion, race, and class. So caste, religion, race, and class. Of course, a combination of this or either of this, you can have compulsory service. Compulsory service, for example, in Israel, you have something called conscription, right? Compulsory military conscription, where everybody has to serve in the Israeli military for a defined amount of time. Again, the state can, India can do something like this, but cannot discriminate on the basis of caste, class, religion, or race, right? Available for citizens and foreigners both, available only and only against the state because it is compulsory service, therefore logical. It's non-self-executory and it is enabling in nature, which means you may have to require further laws for it. A subset of human trafficking is child labor, right? Which is where age plays a very important role. Now, the original provision of Article 24, which says anybody below the age of 14 cannot work in a hazardous employment. Basic CSAT. So, anybody below the age of 14 cannot have any hazardous employment. This means anybody below the age of 14 can have non-hazardous employment. If anybody below the age of 14 can have non-hazardous employment, what happens to Article 21A, which provides for free and compulsory education for 6 to 14-year-olds, right? So that is why 21A has to be read with Article 24. So 6 to 14, no employment whatsoever. 0 to 6 also no employment. 14 and beyond, whether it is hazardous or non-hazardous, we'll get to that. But 0 to 14, 6 to 14, compulsory education. So technically, you cannot be working or you should not be working. It is free and it's compulsory. How it gets implemented in reality is a different story, but this is how both the rights have to be read very, very clearly together. Okay, understood this? Now, available against citizens and foreigners, both state and private, because you can often see private agencies, for example, employing children in firework factories and so on and so forth. It's self-executory and it is compelling in nature. The article itself does not particularly ask the state to make provisions. The state still does, and we have the Prevention of Child Labour Act and so on and so forth. But the article itself is compelling in nature. If you want to make further provisions, you can, and that is why when you make the Prevention of Child Labour Act, it complies with these provisions, and therefore when you have provisions for child artists, it very clearly says education cannot be compromised for child artists, and that law in its list 1 and list 2 gives you a list of occupations or businesses where children can or cannot work, and that is how simple and clear it gets. Okay, then of course you have your religion related rights from 25 to 28, again broad to narrow. So 25 1 and 25 2, we'll look at each of these. So 25 deals with freedom of religion, 26 deals with management of religious affairs, 27 deals with income and religion, 28 deals with education and religion, right? So let's look at each of these. Very clear, very simple, because the chances of this to be asked in the exam is very, very low. One of the most striking provisions of Article 25 Clause 1 is that it is the only fundamental right which is subordinate to all other fundamental rights. It is the only fundamental right that in fact begins with reasonable restrictions. It says subject to public order, morality, health, etc., etc. People will have the right to practice any religion, faith, etc., etc., etc. Right? So it is the only right which actually begins with reasonable restrictions, and it is the only right which is subordinate to all other rights, because one of the restrictions is other rights of Part 2. So what does it give you? It gives you the right to conscience, profess, practice and propagate. Conscience means your basic faith, your choice of faith, whether you want to be religious or not in the first place. Profess is to tell anyone whether you belong to a certain faith or not. Practice is the way you want to practice it, in terms of rituals, in terms of symbols, in terms of ornaments and attire. And propagate is essentially to deal with promotion of religion, almost with a very thin line of religious conversion. Right? These are the 4 words. You will never be asked the meaning of these 4 words, so don't worry too much about it. Available against citizens and foreigners both. Available only and only against the state, because there is no role of the private sector here. it is self-executory, and it is therefore compelling in nature, and this is Article 25 Clause 1. Now Article 25 Clause 2, which is very important, it is that the state can regulate religious practices, and 25(2) allows for the state to do so, which it has subclauses A and B, but the essence is that the state through law, through institutions, can regulate the economic, the financial, the political, or any activity with respect to religion. It also has specific provisions for wells to be open to Hindus, but that's because of a specific social necessity at that time. So for example, witchcraft is banned, human sacrifice is banned. For example, now we have criminalized triple talaq. Certain religious practices can be regulated, right? Available for both citizens and foreigners. It is available only against the state. It is non-self-executory, which means this regulation can only happen through other laws. So that is why it is enabling in nature. 26 is about religious affairs, and religious affairs primarily means that you are able to establish, maintain, manage, acquire or administer any religious property, as long as you're able to do that in consonance to public order, morality and health, and the state will not have a problem with this. You're free to set up your own religious institutions, and for religious purposes we don't have a problem with that. Available for everyone, against the state, self-executory and compelling. And any income that you have through those institutions, through the property, both movable and immovable that you've acquired, any income that you've had will be tax-free, because you're doing the work of God. Again, available to both, against the state, self-executory and compelling in nature. You don't need supporting laws for this. 28, 1, 2 and 3 largely deal with the intersection of religion and education. Basically, 28.1 says, in state-run schools, whether funded by the state or corresponding to state curriculum, no religious education. For example, a couple of CBSE students would have definitely studied the Mahabharata or Ramayana in their CBSE schools. Now that's not religious education. It was taught as a part of your Hindi curriculum under moral philosophy, and the schools can't test you on Hinduism when they taught you that. Again, available for everyone, against the state, self-executory, and this is enough. 28.2 is that, of course, in religious schools, religious education can be taught, and the state cannot interfere in the way religious education has been taught. There are Supreme Court judgments such as the TMA Pi Foundation case, where it says, depending on the nature of the funding of the state, there can be an intervention administratively and on welfare grounds, but that's not important for the pre. Don't worry about it. Available against for everyone, against the state, execute, self-executory, and it's compelling in nature. And 28.3, which has also been the case of a lot of dispute, also gave rise to some derivations to remain silent as well under Article 19, wherein no compulsory religious practices at state-run schools. So you can't force a child to participate in any religious activity, and of course the parent can also take consent or give consent, because the parent is the legal guardian on that front. This is Article 28.3. Again, for everyone, available against the state, it's self-executory, and you don't need supporting laws for this. Not more than this. Don't spend more than 5 minutes on this. This is more than enough, again, as far as your prelims is concerned. Okay. Now, 29 and 30. 29 and 30 are specifically for promotion of minority interests. First, what you need to understand is that there is no legal definition of minority. Whatever is in a lesser population in a defined area is a minority in that area. Now, so 29 deals with the rights that minorities have, and 30 deals with what they can do to promote the fact that they are a minority, to preserve what makes them a minority. So 29.1 gives you the right to conserve language, script and culture. It is available only and only for citizens, because we're talking about minorities, and because we're talking about minorities, we're talking about minorities within India. It would make no sense for it to be given to foreigners, because we're already such a diverse country with such a diverse bunch of Indians. Available only and only against the state. It is self-executory and is therefore compelling in nature. Right? You don't need supportive law for this. However, Article 29 clause 2, which says that there cannot be any discrimination in schools based on religion, race, caste or language, and these are schools which are of course non-minority in nature. If they're minority in nature, then of course you can have a preference for minority students, and reservation policies won't apply. Again, available only for citizens against the state, self-executory, you don't need supporting laws for this, and it is of course compelling in nature. Now Article 30, there was an amendment also made to 31A. Now Article 31 basically talks about religious or linguistic minorities having the right to set up educational institutions of their choice. So whether it is an institution to promote a language or a religious education such as a madrasa or a gurukul or a convent for that matter, you have the right to do so. And if the government is acquiring your land for something and is acquiring your land for the government to help you with this, the government will give you a fair amount of compensation, and there shall not be any discrimination while the government is making policies for different minorities to set up institutions, right? Of course, 31 and 32 are compelling and self-executory in nature, whereas 31A, which is where you'll have to make laws in case there is an acquisition of property, then you would require an additional law to be made, which is why it is enabling in nature. But the basic principle is 30 recognizes the rights of linguistic and religious minorities. The legal definition of minorities does not exist under Indian law, right? This is it. These are your core review of fundamental rights. Now we will look at if all of these are bullets, then where is the gun? The gun is Article 32, right? Similarly, 32 and 226 have the same powers in terms of the powers to issue writs. High courts can issue writs under 226. Supreme Court will issue a writ under 32. Now, what is a writ? Writ, very simply, is nothing but an order issued by a court to enforce a right is called a writ. It is that simple. An order issued by a court to enforce a right is called a writ. Now there are 5 writs, and I've seen this in the UPSC fraternity. I see very complicated discussions on who can file, can somebody on somebody else's behalf file, is it available against the private sector or not, and so on and so forth. So you must understand what is basically happening here is somebody's right has been violated for which they have to go to court. Now there is a somebody and there is a court. The relationship of that somebody and the violation of the right is called locus standi, which means, are you the one whose right has been violated, or what is your relationship with the person whose right has been violated? Are you doing it as a common sort of benefit to humanity at large? And second, are you going to the right court? Does the court even have the power to hear your case? And the court's power to hear a case is called jurisdiction. So there's a combination of locus standi and jurisdiction which also comes into play, right? Now, the basic principle is that the rights are available for, the writs are available for everyone, because if citizens and foreigners both have fundamental rights, then they both have the right to go to court to enforce a fundamental right that they have, which is why writs are available against citizens, are available for foreigners as well as citizens, right? Now, there are basically 5 kinds of writs. They're all written in the Latin language, which is why people get slightly confused with it. But let's understand this clearly and concise. All right. So we've got something called habeas corpus. Now, the primary purpose of an habeas corpus is if somebody has been unlawfully arrested or unlawfully detained. So the court will call that person to be presented before the court. That is the only thing. Now, because you can be unlawfully arrested by the state and unlawfully detained by somebody in the private, so this is available against state and private both. That's the primary purpose of habeas corpus. And if you are arrested, obviously you can't go to court, so somebody else on your behalf will have to go to court, which is why locus standi rules are often relaxed as far as habeas corpus are concerned. It's actually that logical, it's actually that simple, right? Now, mandamus. Mandamus is an order issued by the court when somebody is not performing a legal duty which is violating a right. For example, if somebody stops me from boarding a train saying that I am too heavy for the train, so you're discriminating against me on the basis of my weight. So somebody is not doing their legal duty to allow me to board a train, thereby violating my right to a public space, which is the train. So this is called a writ of mandamus, available against citizens and foreigners both, and available by citizens and foreigners both, but against only and only the state, right? Then you have prohibition. Prohibition is when a lower court hears a case which they are not supposed to hear the case, which they don't have the jurisdiction to hear a case, and have issued an order itself. For example, a consumer court has awarded somebody death penalty. That has violated the principles of natural justice because it is against a free and a fair trial. So, prohibition writs have to be issued by the Supreme Court or the High Court to a lower court. If the wrong court is hearing a case and the case is still pending, the case has not been decided yet, then you can ask for a certiorari and get the case transferred to the right court. So that free and a fair trial, so that you're treated equally, so that principles of natural justice are in place. Then comes quo warranto. Quo warranto is when somebody is occupying a public office illegally, because of which they are taking certain decisions and are therefore acting illegally. This would mean violating any of your 14, 19, 21, etc. So quo warranto, where it says under what authority, but the actual meaning is against anyone who's wrongly occupying a public office, which means it's against the state and therefore acting illegally because you're wrongly occupying it. Even if you're rightly occupying it but acting illegally, then also quo warranto would be applicable. This is all that you need to know as far as writs is concerned. Trust me on this, if there's going to be a question in the pre, it's going to be easily derivable from what we've discussed so far. Now comes the final element, which is often discussed in great depth. Now, the essentials of basic structure. The essentials of basic structure largely originate from a larger discussion, which is, if the Constitution is supreme, then how supreme is the Constitution? I understand the Constitution is supreme. I understand fundamental rights are the supreme of the supreme. I get all of those things. I understand that. But does that mean that the Constitution is immune from any change? Does that mean that we cannot check the growth or the demise of the Constitution in the right place? So that's actually the birth of basic structure, right? Now, let's understand this a little more clearly, right? Now, when we look at basic structure, first things first, let's look at the core articles involved. Article 12. Fundamental rights are enforceable against the state. This is mentioned in 13 clause 2. We've discussed this before. What is a state is actually mentioned in Article 12. Very clearly, state includes central, state and local legislatures and executive. It also includes the administrative dimension of judiciary, but it does not include the judicial side of judiciary. Let me explain this to you. Fundamental rights are available against the state, right? If the judicial side of the judiciary was state, then the judiciary will not be able to decide what is a fundamental right violation and what is not, because no law can violate a fundamental right. For the judiciary to decide whether a law can violate a fundamental right or not, to what extent can the fundamental right be violated, to what extent can the fundamental right be evolved, what is reasonable enough of a law or not, and is the fundamental right really being violated, you've got to be away from the ecosystem, right? If very simple CSAT logic, right? Fundamental rights are available against the state. No law can violate a fundamental right. So if a law is violating a fundamental right or not, then it is the judiciary who gets to decide whether that law is actually violating it or not. And therefore, it is the judiciary that is going to give a judgment that is going to say whether this is actually violating or not. If that process becomes state, then you can never evolve fundamental rights. They remain as static as they are. You can never see the growth of the constitution, which is why the judicial side of the judiciary is not state. This was derived through a Supreme Court judgment called Sunit Batra versus Delhi Administration. The judgment is not important for you, but this is the basic that you must understand. There are some very interesting complications to this, that for example, BCCI, which is the regulator of cricket in the country, is a privately owned agency and is therefore not state. There have been several remarks that BCCI should come under the definition of state, but it is not. Similarly, political parties are not state. So when political parties are not considered state and right to information is a fundamental right available against the state, political parties are not under RTI. So the cycle keeps continuing and so on and so forth, right? Article 13 clause 2 says no law can violate a fundamental right, which means if no law can violate a fundamental right, this has to be decided on a case-to-case basis, and therefore it has to be read with Article 32 and 226, that if a law is violating a fundamental right or not, the Supreme Court or the High Court will have to strike that law down. And if something is being done which is violating a fundamental right, you may need to pass a writ to stop that from happening. So 13 clause 2 plus 32 plus 226 are the conceptual origins of what is called judicial review. And this is very important. Whether it is the word judicial review, activism, adventurism, overreach, basic structure, none of this is mentioned in the Constitution anywhere. What I'm going to tell you now is extremely important. If in the prelims the option says, according to the Constitution, option A, judicial review, statement 1, judicial review is the ability to determine the constitutionality of laws. This is correct, but it is nowhere in the Constitution, so this option is actually wrong. Remember this. Judicial review, activism, adventurism, overreach, basic structure, none of this is mentioned in the Constitution. So what is the meaning of law? Law means everything which is a law, rule, regulation, legislation, orders, etc. However, law does not include a constitutional amendment under 368. The logic is the same. If no law can violate a fundamental right, and if constitutional amendments were law, then you could not make changes to fundamental rights and evolve them, and therefore a constitution would be stuck till eternity, which is why law does not mean a constitutional amendment under 368. Till today, this is still the decided position on law. And Article 368 gives the Parliament to amend the Constitution, and while the Parliament amends any part of the Constitution, the restrictions by 13 will not be applicable. This was added through the later amendments in Article 368 clause 4, which basically means the Parliament can make a law, can make a constitutional amendment to alter fundamental rights, and that is legally valid as long as it does not amend basic structure and all of that. So through the Kesananda Bharati judgment of 1973, the Supreme Court came up with something called basic structure. Okay. Of course, my heart lies in the doctrine of basic structure, and I can go on for hours and hours theatrically explaining to you the journey of it with a lot of legal anecdotes and a lot of fun stories. But what is basic structure as far as the prelims is concerned? The Parliament can amend any provision in the Constitution as long as it does not violate basic structure. And what is basic structure? It's nothing but a set of principles which have been identified through Supreme Court judgments. You don't need to know what judgment identified what is basic structure. That will never be asked because it is a matter of judicial interpretation, right? So basic structure are principles. They are not articles, they are not clauses, they are not subclauses. I'll quickly give you a small sort of a timeline through this because it helps you understand two things. It is a common timeline which makes you understand the amenability of rights as well as the relationship between fundamental rights and directive principles, right? So it all started when the government wanted it all started when the government wanted to set up land reforms. Why did the government want to have land reforms? Because as a country as socialistically charged up as India, land was the most unevenly distributed asset, and most Indians still today occupy the profession of agriculture. Now, land is a finite commodity, which means land has to be taken from people who have excess and has to be distributed to people who don't have it. So therefore, land reforms were needed. But the problem was, at that particular point of time, there was an article, a specific fundamental right under Article 31, which provided for the right to property, which means people had a fundamental right to property back in the day. This combined with right to equality 14 and 19 seem to be violated. Let me explain to you why. When the government creates a land reform, and this by the way has to happen at the level of the states because land is a state subject, but thankfully when we became independent, most governments at the center and the state belong to the same party. So what started happening is that in UP, MP, Kerala, etc., we started enacting land reform laws. So what did we do? We said, for example, in UP, the UP government did, you can't hold, for example, more than 100 hectares of land. Anything more than this will compulsorily be acquired by the UP government. This violated right to property because I have the right to a fundamental right to property and the government is acquiring it, and you're treating landowners and non-landowners differently. And Article 19 clause 1 clause F, which has been deleted, also referred to property as a matter of expression, right? So because of this, several land reforms got executed, and of course our dearest landlords and landowners were mighty terrified and were obviously troubled. So they started filing writ petitions, they started filing petitions in the courts, in the respective high courts, because Article 13 clause 2 very clearly says no law can violate a fundamental right. So these land reform laws were not just violating one right, but were violating three rights. Of course, the petitions started getting entertained by the courts, and as a response to these petitions, the government enacted something called the First Constitutional Amendment of 1951, wherein they added two articles, 31A and 31B. They basically said, 31A, that no fundamental right is violated if the government is acquiring your land, and they went to the market, they created a small little box called the 9th schedule, and all these state land reform laws, they added to the 9th schedule and said, anything which is inside the 9th schedule cannot be challenged before a court of law. So now what happens is, you've created a barrier. In the prelims, there was a question, who was the Prime Minister of India when the first amendment was made, or when the 9th schedule was added? The answer, of course, is Nehru. Now, this then opened up the debate to a larger legal one. So what has happened here is, the government, through an amendment, has restricted fundamental rights and has also restricted the role of the judiciary. Okay? That's the plethora of judgments then follow. From Shankari Prasad to Sajjan Singh to Golaknath to Kesananda Bharati to Yr Kohelo. I would love to get into the details of this, but the basic explanation here is the argument was, A, can the parliament amend the constitution? Can the parliament amend a fundamental right? Because the basic discussion was, no law can amend, or no law can violate a fundamental right. Through the constitutional amendment, through the first amendment, you have violated a fundamental right. So is law inclusive of the same thing as a constitutional amendment? If yes, then you can't do it. If no, then you can do it. This also was the birthplace of larger discussions on what is the constituent power, what is the residual power. The constituent power is the power of the Constituent Assembly to make changes under 368. there's a lot of history and geography behind this. So the government said this is not law because this is ordinary law. The landlord said that no, this is of course absolutely law. Who are you trying to kid? Still about the 17th Amendment and the Sajjan Singh case, of course, the courts took a conservative stand and said that any right can be changed, no problem at all, and constitutional amendments are not law, right? Golaknath was a role reversal wherein the Supreme Court said that no, the Parliament cannot change anything in Part 3 because it is constituent and the Constituent Assembly made it, and constitutional amendments are law for the purposes of it. This was retaliated by the 24th Constitutional Amendment of 1971, where the government, and the 25th Amendment also, where the government made some changes in the aftermath of the emergency, in the prequel to the emergency, where they reversed Golaknath's case. Then Kesananda happened because Kerala land reforms were added to the 9th schedule, so it was challenged in addition to 29 and 30, to which the basic structure doctrine was conceptualized, which said anything. So the Parliament can amend anything to the Constitution. Constitutional amendments are not law, and whatever is added to the 9th schedule before 1973, before the date of this judgment, will continue to be judicially immune. This was reviewed in Yr Coelho, wherein what was added to the 9th schedule before 1973 could also be reviewed if it violates basic structure, right? One of the first applications of Kesananda Bharati was, of course, the emergency case, in which Indira Gandhi had basically passed a constitutional amendment saying that the election of the Prime Minister cannot be judicially reviewed. The Supreme Court struck this amendment down, saying judicial review is basic structure and you cannot make the Prime Minister's election immune. So there's a lot of history behind it. As far as the prelims is concerned, these are the only two lines that you need to know. Anything in the Parliament, anything in the Constitution can be changed by the Parliament as long as it does not violate basic structure, right? And then, of course, is the relationship between rights and directive principles. This actually is a utilitarian principle that in order to develop the country as a whole, if some principles have to be implemented, if a few rights are being sacrificed, is that okay? The outcome of this was decided in the Minerva Mills case, the first non-property case as far as this ecosystem was concerned, because as an outcome of this, nationalization policies were also being implemented. The basic relationship is two directive principles are superior than two fundamental rights. So 39B and C are superior than 14 and 19. If 14 and 19 are the only two objections. 39B and C is anything that the government does for equal distribution of resources and wealth, and anything that the government tries to do to implement this. And if your only objections are equality and expression, then in a scenario like that, these two directive principles will superpower or will overpower your fundamental rights. Okay? Everything else, don't really need to read. This is more than enough. This will get you through as far as these chapters, as far as the prelims is concerned, right? Quickly run you through the reading list. NCERT Class 11 Political Theory, Chapter 5, pages 68 to 74, important, should be done. Indian Constitution at Work, pages 28 to 47, if you have the time, should do it. Your Lakshmikant 6th and 6th revised edition are more or less the same, they're exactly the same. Chapter 7 is rights, Chapter 8 is directive principles, and Chapter 9 is fundamental duties. In Chapter 7, you should do the subheadings which are called features, definition of a state, laws inconsistent with fundamental rights. As far as specific rights are concerned, read the rights pertaining to equality and freedom very, very well. And of course, rights to remedies and writs. The two tables that are extremely important are 7.1 and 7.2. As far as Chapter 8 is concerned, which is directive principles, you should know what the features are, you should know the new principles that have been added. Just read through criticism, utility and conflict once, because sometimes options can be made out of here, and refer to table 8.1 as soon as you can. Chapter 9, which is fundamental duties, just go through the list once and just read through the criticisms. I've already given you the trick. You don't really have to memorize anything beyond the trick, right? So this covers the second half of the fifth lecture. Now I will see you with Parliament, Legislature, Executive all in one lecture. The tough part is done. Everything else is now just an application of the 4 golden rules. I'll see you in the next lecture. Thank you.